May I please, Your Lordship?
Yes.
I beg to mention an unlisted IA for order, my lord. I may be allowed.
Tomorrow. Not today, tomorrow.
Lordship, I wish to mention item number 14.
14.
Matter may be taken about 3 weeks.
3 weeks.
Yes.
On the prayer of Mr.
S. Ram.
Huh?
S. Ram.
S. Year, Learned Counsel for the petitioner. List this matter after 3 weeks.
Lordship, interim order may be continued.
Interim order was earlier said continue.
And Lordship, item number 24 and 27.
24 and 27.
Yes, Lordship.
Why?
Well, in 27, I am the petitioner.
Ah,
We seek a fixed date for this matter, and they may be given last opportunity.
on the prayer of Mr. S. Year, Learned Counsel appearing on behalf of Mr. Item 27, huh?
Yes, for respondents. 1 and 2.
Item 27, huh? On the prayer of Mr. S. Year, Learned Counsel for the Learned Counsel appearing on behalf of Mr. L. Perman.
Keposi.
No, it's item 24.
27.
You are not,
For 24, Lordship, for L. Perme, for petitioner.
you just read first item 24, sorry. So and so, appearing on behalf of Mr. L. Perman, Learned Counsel for the petitioner. List this matter after 3 weeks.
No, my lord, I am seeking one fixed date, my lord.
Item number 27, huh?
Yes. It may be fixed
On the prayer of Mr. S. Year, Learned Counsel for the respondent. List this matter after 3 weeks. Mr.
Yes, my lord. It may be fixed on 20.
N. Basar.
B near.
Huh?
My name is not there in the course this one.
Mr.
B near.
Learned Counsel appearing on behalf of Mr. Arson, Learned Counsel for the petitioner. What is it? What is the order? 3 weeks, huh? Binod B.
B near.
Nyaruch. Learned Counsel for the Learned Counsel appearing on behalf of Mr. Arson, Learned Counsel for the petitioner. Praise for a fixed date. Accordingly, list this matter on
20th of this month.
Huh?
20 May.
No, after 3 weeks, how it can be 20 May? After 3 weeks.
My lord, after maybe fixed on this month, my lord, because these
He has asked for 3 weeks.
3 weeks.
For reply file करेगा, affidavit file करेगा.
My lord, already they are doing this tactics because the matter is pending trial, and if the trial is complete, then it will become infructuous.
Doesn't matter, it's okay.
Lordship, Mr. Keposi has read for reply for filing affidavit.
No, then in that case, not 3 weeks. 2 weeks. After 2 weeks, give the date.
20 May.
20 is not, today is 9.
My lord, can be fixed a little bit earlier because they have been seeking for the same reason.
After a week.
Yes.
Then list this matter on so and so. Understood? In item 24, it's appellant, not the petition.
Lordship,
Yes.
I beg to mention item number 21 for the petitioner.
Hmm.
Service report in respect of respondent number 2 is awaited. Lordship,
We'll see. You be there. He's in the order.
public.
My lordship, I beg to mention item number 1, lordship.
Yes. What do you want?
Mention, your lordship, after 2 weeks, lordship.
You're for
Petitioner on behalf of E. Permit, lordship.
Mr. So-and-so Learned Counsel appearing on behalf of Mr. MSE Permit Learned Counsel for petitioner. Press for listing the matter after
2 weeks, your lordship.
2 weeks. List according.
Obliged.
My Lordship, I beg to mention item number 25, Your Lordship.
25.
25, on behalf of JGNE, Lordship.
What is this?
It is in supplementary. Council is out of
On
station.
the prayer of Mr.
T. Tarin,
Tang, appearing on behalf of Mr.
Okay.
J. Learned Counsel for the petition. List this matter after 4 weeks,
2 weeks, Your Lordship.
2 weeks.
2 weeks. Obliged.
My lord, I beg to mention item number 28, my lord.
28.
I have taken the consent from the other side, my lord. I'm
Yes.
on behalf of the respondent council. So matter may be fixed after 3 weeks, my lord.
Why?
Today, the leading council is
You
in
have
this
take-
post, my lord.
You
Yes, my
have
lord.
already received the money, compensation.
No, my lord, the money has been deposited 50%. 50% has been deposited,
I have deposited.
my lord.
You will dispose it of, you pay entire amount.
That may be fixed money.
Huh?
After we,
What is there in the appeal? There's
The-
nothing.
interest is higher, there is some merit for appeal, my lord. Because the income and interest.
On the joint prayer of Learned Counsel for the parties, list this matter after
2 weeks, my lord.
3 weeks.
3 weeks. Deeply obliged.
Obliged.
May I, Your Lordship? Your Lordship, I beg to mention item number 18.
18.
Your Lordship, the conducting counsel is on leave, and to that effect, he had already submitted his letter of absence. His name is listed and is reflected on the array of advocates who are on leave at page number 7, Your Lordship. Therefore, Your Lordship, this
Is it a ground to adjourn the matter? You be there, we'll see. It's in order stage. It's listed for orders, we'll see. You be there.
much obliged.
Your Lordship, I beg to mention item number 6 on behalf of Dugas Oki.
Item number
6.
6. On the Mr.
Sita.
Sita's Learned Counsel appearing on behalf of Mr. D. Shoki, Learned Counsel for the petition.
Your Lordship,
Press for listing the matter after 3 weeks.
2 weeks.
After
Your
2 weeks.
Lordship, there is interim.
Praise the Lord. This matter after 3 weeks. Interim order pass, earlier shall continue.
Much obliged.
Your Honor, I'd like to mention item number 15 and 16. I've taken the consent from the other party.
We'll see what is to be done. You be there.
Obliged, Your Honor.
Item number 2.
Yes.
The petitioner has, the appellant has, this is the second appeal, Your Lordship. The appellant is challenging the order of the district judge in rejecting the, in this case, file for conducting a delay of 273 days, Your Lordship.
Yes.
What has happened in this case is that the petitioner, may I take a lordship through the facts, Your Lordship?
What is the improved order?
It is at page number 58, Your Lordship.
Yes. Yes.
My lord, the petitioner is challenging the order on the ground that that the lower court. They have, I'm sorry, Your Lordship. The main ground that the petitioner is challenging is that when they're on the ground that when there is a substantial justice and there's a technical consideration, the honorable court ought to have taken into consideration the substantial justice, Your Lordship. And the lower court has also failed to take into account that the petitioner was an old person, Your Lordship, of 80 years. And also the fact that the grandson of the petitioner had met with an accident.
Yes. You have to explain, how many days of delay?
273 days, Your Lordship.
You have to explain. You have not properly explained.
My lord, the petitioner has explained, but not each and every hour, but then he has
See,
given-
you first ground is that you have received you had the knowledge of the judgment after 2 months.
2 months.
Right?
Yes, Your Lordship.
Thereafter, you didn't do anything. There's in between, there's nothing. Then your grandson met with an accident.
Yes,
Thereafter, because you have been traumatized.
yes,
Even after that, you didn't do anything. Thereafter, you consulted a lawyer. There was another gap.
yes, Your Lordship.
Even after that, you filed the appeal, of course, with the condonation application. There were 3 gaps
Yes, Your
where
Lordship.
you could not properly explain.
Yes, Your Lordship.
It appears to be a little back. I think the court below is rightly rejected your appeal. Yes.
My lord, but then the Honorable Supreme Court has held that each and every delay ought not to be explained, Your Lordship. And if there is a case of denying justice, Your Lordship, then there is a substantial justice and technical considerations are pitted against each other, Your Lordship. The Honorable Court ought to take into account the substantial justice, Your Lordship.
No, first you have to explain the delay. 3 gaps you could not explain.
Yes.
Even the lawyer is contributed the delay.
Yes, Your Lordship.
Your lawyer also contributed the delay. Third part. There's nothing about, there's nothing, you have not said anything on that. Yes, proceed.
My lord, I'm still on the fact that on this, Your Lordship, on the ground that a pedantic approach could not have been taken by the district judge, Your Lordship, for
Okay.
not condoning the delay of 273 days. Each and a delay of, I'm sorry, Your Lordship, delay of explanation of each and every delay ought not to be done, Your Lordship, if there is.
Normally it is, but then in certain cases it may not be required. But then it has to be, you have to show some sufficient cause.
My lord, the medical certificates are also annexed. Your Lord.
You yourself were not, what is the medical certificate?
Starts at page number 32, Your Lordship, annexed 2.
30?
32, annexed 2 series.
Yeah, we're not disputing it. Nobody is disputing it. This is the medical certificate of your grandson.
Yes, Your Lordship.
You, despite having a traumatic situation, you actively participate in various keva.
My lord, that is also one of the grounds that I'm urging upon your lordship. This is also one of the grounds that I'm urging upon your lordship.
Yes.
There is no evidence to show that the petitioner was involved in holding kabang proceedings, your lordship. It was only on the basis of oral statements and oral submissions, your lordship, and written argument. There is no evidence to that effect, your lordship.
Yes. What is the judgment you are relying on?
1987 to SCC 107.
What is the delay of 7 years, 7 months?
1987
1987
to SCC
USCC
107.
107. Paragraph.
My lord, paragraph will be 3, your lordship.
Paragraph
3.
3. There was in this case, there was delay of only 4 days.
Yes, your lordship.
Huh?
But then the Honorable Supreme Court has laid down the grounds on which a delayed application had to be considered, your lordship.
Yes.
Lordship, this present,
You point out on merit, on appeal, because he has a statutory right. Appeal is a statutory right.
Lordship, this is application under section 100. And under section, this is second appeal, where only the substantial question of law has to be decided by the honorable. Now, dismissing of rejection of the IA application on the ground that it was not explained, there was no sufficient cause. Whether that will be the substantial question of law, that has to be seen. Garnet court below rightly rejected the misapplication also. Only the explanation given by the applicant before the trial court for condemnation of 273 days delay. It was bike accident of his grandson. And thereafter he got some health issues. serious sick since November 19 to December for only 1 month also. But before that, he could have filed his statutory appeal also, civil appeal, but which was not done on.
This substantial questions which you have framed,
Yes, Your Lordship.
I don't think, Mr. Pangi, please come forward. Page 9.
Yes.
This cannot be a substantial question of law. He may be correct.
My learned friend is in fact better prepared. I have not even seen the file. She has some judgment, maybe she can rely upon. I know this Honorable Supreme Court says a question of law having a material bearing on the decision of the case. That is, a question answer to which affects the right of parties to the suit. Here also, my lord, since my lord, the decision of the learned appellate court, first appellate court, in not considering the whatever my lord has submitted, would my lord
Other than
affect the right
other-
of the parties to the suit?
Other than the section 100, don't you have other remedy under CPC?
Uh, in fact, we filed this under
Section
CRP
100.
earlier, but this honorable court, Justice Mehdi was sitting and he was of the opinion that the second appeal would lie. That is how this came to be filed.
But for second appeal, privacy, I don't think the questions, substantial questions you have framed. Is the question?
This is the substantial question of law that my lord the appellant has put before lordship, but your lordship on the basis of the facts will frame the substantial question of law, not us.
That you can drop the question.
Yes. Because if this is the law that any question of law having a material bearing on the decision of the case, that is a question answer to which affects the right of parties to the suit. Then, my lord, in that case, लिखा था कौन सा होगा?
Wait.
2007 8 SCC 155. इसको दे दो. Paragraphs might be different. Same, right?
It's 155.
Yes. Paragraph is paragraph 3. There's here everything has been quoted, and lastly comes to page 160, my lord. Roman 2, small Roman. So, my lord, reading this paragraph, if the Honorable Supreme Court has said, laid down in respect of delay, that a equitable approach be taken, then, my lord, this may apply. I'm putting it this way, my lord. If the law laid down by the Supreme Court in respect of delay is that a liberal approach should be taken and not a pedantic approach, then, my lord, this paragraph would apply and, my lord, then there will be a substantial question of law. If the first appellate court has gone beyond what is the settled position, contrary to the settled position of law, my lord, that would be a substantial question of law.
But
In
it
my humble
says, to be a substantial, a question of law must be debatable,
Yes, ma'am.
not previously settled by the law of the land or a
Yes,
binding
yes.
precedent.
I read further, my lord.
Hmm.
A substantial question of law will also arise in a contrary situation,
Hmm.
where the legal position is clear, either on account of express provisions of law or binding precedents, but the court below has decided the matter either ignoring or acting contrary to such legal principles. In second type of cases, the substantial question of law arises not because the law is still debatable, but question of decision rendered on a material question violates the settled position of law. That is, in this context, I am submitting, my lord, if it is the settled position of law that while condoning delay, my lord, the liberal approach has to be taken. And the first appellate court has taken a pedantic approach, my lord. Then, my lord, this will be a question of law, my substantial question. Ultimately, but it is upon your lordship, my lord, to frame the question of law. So we have submitted, depending on the facts and circumstances of the case. I understand, my lord, the drafting in the first appellate court was not happily done. Fine. Aye. Yeah.
Okay.
The grounds on which delay was sought to be condoned is at paragraph 10, 11, and 12 of the interlocutory application. That is at page 54. If your lordship finds that this was sufficient ground for the first appellate court to condone the delay, then it may be a substantial question of law in my humble understanding. Huh? ये ग्राउंड भी आएगी डिले ये करने का रिजेक्ट करने का वो ग्राउंड है and my lord, one more aspect. While rejecting the application for condonation of delay, it appears oral submissions with regard to the applicant having attended some kavas were taken into consideration. To that effect, my lord, it is in the same judgment. कौन सा को बोलो? It says, from the well-recognized exceptions are where the courts below have ignored material evidence or acted on no evidence.
This question has not been framed.
Not fair.
We'll frame it today.
Right.
In
Up
view
to-
of, my
up-
lord,
up-
on view of judgment.
Up to my lord, if there is a
It's, have you
substantial
gone
question
through
of
this?
law,
Have you gone through this?
yes, Lord.
When you, at the first place, when you read the first part, there's nothing, but you read the second part. We'll frame this issue, I mean, questions. Heard MS did a learned consent for the petition and also heard Mr. K. learned consent for the respondent. Following substantial, the following substantial questions. The following is the substantial questions in the matter, which is being framed for adjudication of the present petition. Number one. As to the certain position of law that when substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred. For other side cannot claim to have vested in injustice being done because of a non-delivery delay. Has been. Has been. What is that first line? No, it's true. Not delivery. Non deliberate delay. You take the judgment, huh? Page 108. 1987 to SCC 107. Come on. The impure order rejecting the impure order dated
18/12/2022, Your Lordship.
the learned trial court has rendered has ignored the settled position of law while rendering the impure order dated so and so. Is it so?
Lordship.
Is it so? Can
Lordship.
it be a substantial question of law because of the Supreme Court judgment?
Substantial lordship.
Supreme Court has settled that when the substantial justice and the technical consideration are pitted against each other, the cause of substantial justice has to be considered, preferred. And if it's not only that debatable or what do we call it? if there is a debatable legal issue, it could be a substantial question of law. But if the court rendered in ignorance of the settled position, that also is also a substantial question of law. We'll see. Admit, list for hearing.
Replay of life.
You give this to them. I'll also examine, but this is the one substantial question.
Whether your lordship would like to take this up?
Huh?
Whether your lordship would like to take this up?
Yes. This before any other improvements without
Problem.
Yes, sir.
Your lordship.
Yes.
You know, this matter is pertinent to the CGM order that is passed on 9 the order that is passed in CGM court dated yes. You know, let the LTR may be called from
No,
the,
my lord, LCR is not required, my lord, in this case, because that's money shoot is at the very initial stage. Issues has not been framed. We have annexed the plain written statement and the miscase and the objection in the miscase and the impugned order, my lord. If my learned friend is not prepared today, let it be taken up on some other day. But LCR, my lord, it will delay the matter in the money shoot, my lord.
since the order has been passed in your CGM, let the
LCR
LTR
is not
be called,
required, my
my lord.
lord.
This the impugn order is
The impugned order is at page 232, my lord.
232.
232. We have, my lord, we play, in the plain, we have prayed for 100 crores against the defendant, my lord, for recovery. 100 crore, my lord.
No,
Because-
200. The impugn order
Impugned order is at 232, my lord.
32.
232. We have filed one miscase, my lord, miscase number 80 of 2022, for attachment of the properties of the defendant, my lord. And the learned trial court, my lord, while making certain observation, has rejected on the ground that we have not given the property valuation of the property, my lord. So my humble submission is that the properties can be assessed anytime, my lord, my lord. That should not be a ground for rejection, my lord. The operative part, my lord, will start from page number 227, my lord, 227. 227, my lord.
27.
227, my lord.
227.
227, my lord.
What is the operative procedure?
It's
You said impugn order is page.
impugned order is at page 223, my lord. It starts the order dated 9/1/2023.
There is 232.
223, my lord.
No, it's 232. 09/01/2023.
That is the that one is another matter in which that was allowed, my lord. We have filed two miscase. One miscase was rejected and another miscase was allowed.
Yes. Okay. Same there.
The different order, my lord.
Yes.
That which one was allowed, it is at page 232, 9/1/2023. The operative part is at page 235, my lord.
No distributed.
235. Hence, on the basis of the aforesaid reason, by invoking the power under section 151 CPC, the opposite party defendants are hereby directed to disclose their assets by an affidavit filed before the court before the next date for the ends of justice. and to prevent the abuse of the process of the court. So accordingly, they have filed an affidavit and disclosed their assets, my lord. Whereas we have filed another miscase, my lord, for attachment of the property of the defendant, my lord, before the judgment, under Order 38, Rule 5 and 6. That miscase was rejected.
Yes. According to the court below, you have to specify the property required to be attached.
That
And
we have
estimated
specified,
value.
my lord, the learned trial court had held that we have not given the estimated value of that property, my lord. My lord, just I will read the 2 pages, my lord, the operative part of the order. It starts from page 2 to 7, my lord.
Are you ready?
No, Your Honor.
Who is your senior? Are you appearing for that?
Arkoyu.
Huh?
Arkoyu.
Arkoyu.
Yes, Your Honor.
Just read it. Let us see.
Yes, ma'am. From the combined reading of the provision of Order 38, Rule 5 and 6 secrecy with above case laws, it can be seen that the power of attachment can be exercised by the court when the court is satisfied that the defendant with intent to obstruct or delay the execution of any decree that may be passed against him is about to dispose or remove his property. Further, state power is an extraordinary power and should use sparingly and strictly in accordance with the rule, and that the affidavit in support of the contentions of the applicant must not be vague and source of information should be disclosed, and the grounds for itself should be stated. A mere allegation that the defendant was selling off his property is not sufficient. In the instant miscase filed by the applicants, it can be seen that the applicants have averred therein that the applicants have learned that the opposite party is trying to transfer the ownership of his immovable properties in his relative name in order to escape liabilities due to the present money should, but have nowhere stated the source of the said information or the grounds for belief. In absence of such source and grounds for the belief, in my considered opinion, averments made by the applicants about opposite party defendant trying to dispose of his property in order to escape liabilities of the instant money suit is vague. Accordingly, this court is not satisfied by the affidavit filed by the applicant stating that the opposite party with the intent to obstruct or delay the execution of any decree that may be passed against him is about to dispose of or remove his property in absence of the source of applicant's said information being stated or the grounds for such a belief stated or related information documents stated by the applicants. In addition, Order 38 Rule 5 CPC requires that the plaintiff shall specify the property required to be attached.
Okay. Since his senior is not, what can be done?
My lord, a fixed date may be given in the first week of June, my lord.
Can we admit it and fix for hearing?
It can, yes. Can be admitted and fixed for hearing.
Heard Mr.
BK Singh, my lord. BK Singh.
BK Singh, learned counsel for the petitioner, and also heard Mr.
Eshtai.
Esther, learned counsel appearing on behalf of Mr. Arkoy,
Yes,
learned counsel for the respondent. Only one respondent.
Two, Your Honor.
Huh?
There are two respondents.
Two respondents.
Yes.
Are you appearing for all?
Yes, Your Honor.
Hmm?
The respondent two is the proprietor of the
Both
CPF.
respondents is appearing.
Huh?
Is appearing, they are appearing for the both respondents.
Okay.
It's the firm and the
You don't file, you don't want to file anything, any objection, whatever?
I have to seek instruction from my senior, Your Honor.
It's up to you. So we'll admit this or we'll just adjourn the matter.
May admit it and fix for hearing.
Matter may be adjourned, Your Honor, since my machinist instructed me
Yes,
to.
when do we want? We'll see it on next day.
After
Because
three, after
they
3
may
weeks.
say that we have not been heard.
On 6th, my lord, 6th of June.
The, on the prayer of Mr. What is the order? Not say. Mr. B.K. Singh, learned counsel for the petitioner is present. Mr. S. the learned counsel appearing on behalf of Mr. R. Ko, learned
Yes, sir.
counsel for the respondents. Press for listing the matter after 2 weeks, after 3 weeks. Mr. President, on the consent of, as agreed to by learned counsel for the parties. List this matter on
6th of June.
06/06/2024. In the meantime, respondents may file
Objection if any.
any file response if so advised.
Oblige, my lord.
Yes,
Well,
my lord.
this-
Lord, I'm for the petitioner. We have, on last occasion, Lordship, the LCO was called by this honorable court to
Yes,
ascertain whether the kabang which took place in the year 2011 and the 2022, it's there in the record or not. But from the LCR record, Lordship, it seems only the execution petition which is pending before the Deputy Commissioner Pasigat has been furnished, Lordship.
who appears for the other side?
I'm appearing, my lord.
Yes. What is to be done?
My lord, the main issue in this case is that there has been multiple kabangs and it is not permissible in law. Now, the LCRS he has submitted, it's
Only the execution.
yes, that's not even the main issue here. So that may be needed. There were in total 3 kabangs according to him.
LCR should be all those.
It
Kebangs. Normally,
they do keep
do they file the Keba decision before do they place the transmit the records to the deputy commissioner?
that I don't know, but they do keep a record of proceedings with the head Gambura.
They've sent the original petition.
That's not the main issue even.
Huh?
His contention is that they were earlier kabangs, so that kabang could not have been executed.
Hmm.
So therefore,
The last line you just did. The records from the deputy commissioner relating to deputy commissioner Asian district record, record relating to from the record of execution proceedings from deputy commissioner Asian district is received. Mr. Howard, on its perusal, it contains only the application for execution of degree of the KEBA and the order sheet of the deputy commissioner, which is incomplete or which appears to be incomplete for proper adjudication of the present matter. In view of the records, including all the, how do we get those other KEBA?
it's in the bottom, it's written, it's in
In view of the above, the entire records, including the various KEBA decisions.
yes, dated, that if it can be mentioned, the dates of the alleged kabang.
Yes, KEBA decisions, dated
17/4/2011, 29/5/2011, and 39/2022. It's
Be- be called for.
Yeah.
We'll keep it here or we'll send back.
that is, it can be sent back, it's of no use actually. Obliged.
List after 4 weeks.
Lordship, there is an interim that may
Entry vote plus additional continue.
deeply over.
Your legal aid counsel was appointed for private respondent number 2, legal aid counsel.
Is
She
it
is-
appointed?
Yes, she is Miss Jadaji. And she is not present.
Who is
Here
for
to-
petitioner? Who is legal aid counsel?
Jayadaji, Miss Jayadaji. For petitioner is one D. Loy. And
One
his
appears for the petitioner as well as the respondents. Mr. Dita, the counsel, learned additional PP for the state is present. List after 4 weeks.
And counsel for private respondent has filed the affidavit in oppositions. And I've not been furnished with a copy.
You ask her.
Always.
Yes.
My lord, yes, I checked the record. As per the record, ID card of in respect of respondent number 2 is not yet received. So in that case, I may be allowed to take fresh stay. And the hearing may be fixed on fixed date on 24 of this month.
Yes, Your Lordship.
You have the case diary?
Yes, no, Your Lordship, PCR was called for.
Okay.
Yeah.
What is the offense?
Offense, it's section 376 IPC, read with section 4 of POCSO Act.
What is this additional affidavit?
Yes, it's
What is the additional affidavit?
it's regarding the medical discharge slip of the accused murder.
You want to take press steps?
Yes. Since this is
Mr.
Jitadi.
Jitadi, learned counsel for the applicant. Press that he may be granted some more time to take press steps for service of notice upon respondent number 2. The prayer is allowed. Petitioners to take steps for learned counsel for the petitioners to take steps for service of notice upon respondent number 2 within 3 days. List the matter after 2 weeks.
No, matter may be fixed on 24. Hearing may be fixed on 24.
How you will take this service? How will affect the service? Notice.
Today itself, I'll take step.
From where?
From registry.
Where is the petitioner?
Papumpare.
Okay.
Yes.
After 14 days, list the matter on
24 of this month.
Then you take the steps within during the course of the day. You take the steps today.
Yes.
Press the steps today.
Yes.
All right.
Yes, ma'am.
Number 9.
Yes.
Your Lordship, this is a bail application which I have moved. I was arrested on the basis of an inquiry report which was conducted by the police.
Huh?
CD.
Made.
Yes.
The case was registered before the Teju police station under section 304/34 on the basis of an inquiry report submitted by the inquiry officers. May I read that inquiry report, which is page number 9 and actual 1. This is the
page number 9.
9.
Yes.
Made. This is to inform you that today on 18/3/2008 at around 19:55 hours, 3 children, namely Miss Rita Tati, Sri Sita Tati, and Ajay Tati, care of Dhananjay Tati, a resident of tribal colony behind Government Higher Secondary School, POPS Teju, appeared at Teju PS and verbally informed that one unknown person who was assaulted by some person and kept in front of their house has been lying unconscious or dead since morning. On getting this information, Self-Inspector G. Disis, where ready party rushed to the spot to verify the matter. As per the lead of the informant party, Ms. Disis, the party reached the spot at around 20:30 hours, where a dead body of one late Jabom Basar, son of this resident of diseases, has been found lying dead on the footpath on front of the house of one Mr. Dhananjay Tati, adult. This in cultivation field area with some fresh injury marks on his body parts, whereas the trio informant have been found to be the children of Mr. Dhananjay Tati. On inquiry, Mr. Dhananjay Tati and his children revealed that the person was brought in front of their house by some laborers from the nearby construction site located around at the rate about 200 meters away from their house, carrying in a jute sack. It was revealed that late this and Sri Gopal Tati, son of Dhananjay, were beaten up at the construction site on being caught trying to steal the iron rod from the site in the morning of 18/3/2024. Later, at about 8 hours of 18:30, Sri Gopal Tati was released by the party after beaten, whereas the late Jama was brought in front of Tati house by the laborer carrying him in a jute sack after beating him. Immediately, the laborers, namely Jainal Ahmed, resident of son of Fajul Mia, is along with caretaker, namely Abdul Roof, son of this, were examined at the site itself, where they revealed that the duo led this Jumbom Basar and Sri Gopal Tati tried to steal the iron rod from their site, where they caught them red-handed at around 400 hours of 18/3/2024 and informed their site owners, Mr. Batuk Sukri, on which the owner, along with wife, came to the site at the rate 700 hours, and they both beaten up the duo with some sticks, and later they have to carry late Jubam Basar up to Dhananjay Tati's house in a jute sack in conscious state after beaten him as per the direction of the owner. Mrs. The jute sack with jute rope and the dried bamboo used to carry this from the site to the spot were also recovered and seized as per the disclosures of the Tikadar Abdul Rif. The body of late Basar was taken to Jeddah, where the concerned doctors declared him both dead and thus kept in mortuary for further course of legal action. This is submitted for your informations and necessary action, please. Here, the role of the petitioner is I'm a construction laborer working in the construction site. In the early morning, the deceased persons, along with one person, they came to steal the iron rod. Then we caught them and informed the Tikadar, and who in turn informed the owners. Only our role is that we caught them while stealing the iron rod. And we had that taken part in beatings, and whatever was done, it was done by the owner who came to the site. And as per the instructions, we had kept that persons in front of that Dhananjay Tati. This is an admitted exam. We were examined. The police had asked everything. 161 statement was recorded. And even the other Gopal Tati, his 161 statement was recorded, 164 was recorded, and we had filed an applications before the CGM court for release on bail, because our role is only after that we had caught them red-handed and informed that incident to the owner of the construction site. And Your Honor, I had annexed that I had moved in bail applications before the CGM court, which was rejected.
What is the name of the accused?
Accused is two accused. One is
No, one by one.
One, this is Abdul
Muin.
No, not Abdul. Abdul Hussein. Abul Hussein.
He's not named in the FIR.
He's not named in the FIR.
Yes. You admit that you caught this deceased? Huh?
Yes,
While
yes,
stealing.
Yes.
And then what did you do?
We informed to the caretaker.
That's all.
That's all.
You have not beaten them up?
No. Not.
Yes. From CD, it reveals that they have caught these two victims, one who later on died, and they tied them, these laborers, these accused, tied them in these concrete pillars, RC pillars, and they informed the owner. And owner of the site is a prime accused here. Owner and his wife has beaten these persons and another victim. And 164 statement of this another victim who is still alive. Clearly, he's the now main eyewitness who happens to be present on that similar region. He this 164 statement given by that another victim is a main eyewitness.
So what did he?
He, in his 164 statement, clearly says that this accused also participated in this beating incident.
He has also beaten the deceased.
It was not clearly says that he was beaten, but he was participated in the sense that in youth's bag, they put the accused, deceased person, and carry them to the nearby place. And they are the person who tied the deceased in RCC pillars. So they are here, herein they are roped under section 34 IPC, common intentions. And prime accused is now still absconding. Wife of the prime accused was not arrested because she is pregnant. So at this stage, investigation is not yet over. It's still incomplete. And whereabouts of the prime accused is not revealed by even wife of the prime accused. So this bail application may be rejected because
Laborers.
and they are migrant laborers. They are migrant laborers.
Minor.
Migrant. So they may be not available for trial if they get released by now. Charge sheet has yet to be filed.
Whether their custodial interrogation is required.
No, that part is over.
Huh?
Custodial interrogation part is over. Custodial interrogation part is over. Yes. Only because this is a serious offense whereby death was ensued.
You said there's nothing on record to show that even 164, 161 doesn't show that he has beaten the deceased. He only caught while stealing the rod, iron rod. And
Yes.
tied them.
If section 34 is established, 34 IPC, that means they are equally liable for furtherance of common intention.
It's okay. Now, whether custodial interrogation is required or not, that is to be seen only.
Now they are in judicial custody. Now they are in judicial custody.
So it's not required.
That part is over, not required.
Or Mr. D. They are the consent for the petitioner. Applicant also had Mr. G. Tado, learned counsel, learned additional PP for the state. This is an application under section 439 of CRPC, 1972. Praying for grant of bail to the accused Janal Ahmad. Huh?
Yes.
Janal Ahmad, who has been arrested in connection with. What is this? PS case number 28 of 2024 under section 304, public 34, IPC, who has been arrested on 1903-2024. You have not arrested the main accused,
Yes, still absconding.
Tony. The present bail application has been erased out of the has been filed. In connection with the PS, KGPS case number 28 of 2024 under section 304 of public 34 IPC, which has arisen out of the consequent to the registration of FR. An FR has been lodged by one Mr. Govind Arangbam on 18/03/2024, which is reproduced here in below, page 19, huh? And socials. Mr. D.K. Learned counsel for the petition. Submits that the accused person, Mr. Ainal Ahmad.
Yeah, Jailal.
Jailal Ahmad. Come on.
Jailal.
Is a laborer engaged in a construction site. Under Mr. Batung Chukri.
Yes, Batung.
The accused is not, the accused is innocent and was not involved in assaulting the deceased. He, along with other accused, only apprehended the deceased and one person while they were stealing the iron rod from the construction site. He further submits that the accused person, along with his friends, after apprehending the deceased and one more person, informed the inform his employer, Sri Batung Sukri. If at all, it would be it may be his employer who has assaulted the deceased. Next one, Mr. Brigadier learn concept for the semester. The accused has been was arrested on. When he was arrested? 19/03/2024. And since then, he's in the judicial custody.
Judicial custody.
There is no requirement of custodial interrogation. In fact, the accused has already recorded this. The police has already recorded the statement under section 161.
161.
CRP. And also 160.
No, not
161.
Only 160.
Therefore, he submits that there is no reason to put the accused in the custody. And I said, his praise for release of the accused person on bail. Any conditions and terms that may be imposed by this court. Mr. Gita, learned additional PP, while referring to the case diary, submits that as per the statements recorded under 161 as well as 164 CRPC, of the witnesses and the accused and the witnesses, accused person and the witnesses, it is revealed that the accused person, after apprehending that this is that one person, this is one more, one other person, tied them in the cement post, cement
Yes.
at the construction site. Thereafter informed his employer, their employer. The employer in his turn has assaulted the deceased and other persons who have at least to have been stolen the iron rod, which led to death of the deceased. Therefore, the ingredients of section 34 is clearly attracted to the accused, Mr.
Jainal.
Mr. Judge, he submits that the petition, the accused is not entitled to be. No. Before that, he submits that the main accused, one Mr. Batung Sukri, is yet to be arrested. Is his absconding urgent today. The investigation is yet to be completed. Therefore, he submits that the petitioner, the applicant is not, the accused is not entitled for release on bail at this stage. Is releasing the accused at this stage would impede the proper investigation of the matter. Mr. Consider the submission of learned concerned parties and also peruse the case diary. In the perusal of the case diary, the accused has stated under section 161 of the CRPC that he has apprehended deceased in one more person while they were stealing them. They were caught stealing the iron rod in the site. One Gopal Tanti, huh? That one other person is one Gopal Tanti. Gopal Tanti. Thereafter, they were tied in the cement post. Cement pillar or post?
Cement pillar.
Cement pillar. And informed their employer, one Mr. Batu Sikri. The said Batu Sikri and his wife came to the construction site where the deceased and one Gopal Tanti were apprehended and tied up, and they have assaulted the accused and assaulted the deceased and the Gopal Tanti. Next pair. The on consideration of the case diary come up. It appears that no further custodial interrogation is required, although the main accused is yet to be arrested. Having considered the materials come up, I'm of the view that no impediment will cause to the investigation if the accused is released on bail as agreed to by the learned additional people, that no further custodial interrogation required in view of the nature of the case.
But TIP is yet to be done.
Huh?
TIP, test identification period is yet to be done. Not yet done.
Is it a ground for not releasing the accused on bail?
If tomorrow accused never
We'll
tells up
give a strict, whatever condition you would like to impose. By this code, you tell us
general condition as and when
accordingly. Next pair. Next pair, huh? In view of the come on. I deem it appropriate to release the accused, to grant the accused to be released on bail. Accordingly. The accused, Mr. What is that?
Jainal.
Jainul Ahmed. Jainul Ahmed.
Ahmed.
General Ahmed, be released on bail on the following terms and conditions. Number one, what?
He shall not temper the evidence.
Ah,
He shall not temper the evidence.
much more than that.
Since he is from outside of the state,
You read that the accused shall furnish a bail bond of rupees
25,000. Because since they are lever, 20,000, I think.
25,000.
20.
20,000.
20. Since they are lever.
It's big enough. For level 20, 10,000.
Okay.
With surety of like amount. Local surety of like.
yes.
Local surety. I will try. If not, then cash.
No, will not say that. Local surety of like.
Two surety, Your Lordship.
No,
One
If
Pro-
not local surety, then two surety of
Huh?
like amount. Two surety of like amount.
one local and
So
one
local, I don't
Procedural.
think it will be
Huh?
possible. Because if one from his own family,
No, suppose if he goes away from there.
no, he will be not.
No, we cannot say that.
Two surety of like amount. That will suffice.
Two surety of like amount, which one will be a local.
Local, yes.
Possibly. Because it is not possible because that is tantamounting to not giving bail. Otherwise, if we fail to arrange that.
You file an appeal in that case. And the accused shall not all those conditions include. And to leave the jurisdiction without the permission. Then to appear
before the
one more before the IR once in a week. Because many accused has not
Yes.
been arrested.
As a once in a week
For 1 month.
for 1 month. So.
Other one is name will be different.
Yes, name of the but he is not a named accused in the
Huh?
FIR. The other one is not named in the FIR.
Okay, what's his name?
Abul Hussein. I don't
So
know.
you delete that person. We said the accused has not been named in the FIR. In this case, don't say anything. You delete that. In this case, this is Abul
Hussein.
Abul Hussein. Well, application disposed. Allowed and disposed.
CD may be returned. It may be reflected.
CD be returned.
May I?
Yes.
It's a previous bail application, my lord. By my lord, interim bail was granted, my lord. With cooperating with the investigation, my lord. The applicant herein, my lord, is presently is the assistant commandant of IRBN, my lord. So during 2018, my lord, the applicant, my lord, was the officer in charge of the Duimik police station. So during that time, my lord, an FIR, my lord, on 28 April 2018, an FIR was lodged by one Mr. Tagung Niri, who is the applicant in the item number 12, my lord. So against the informant of the present case, inter alia saying that, my lord, he has cheated him, saying, my lord, he has misrepresented himself as the owner of 4 excavator, my lord. Mr. Tagung Niri, my lord, he is a contractor, my lord. At that point of time, he was undertaking this construction work at Yangkyong, my lord. So what this informant did is like, my lord, an rental agreement was executed between Tagung Niri and the present informant, my lord. Advance amount of 14 lakhs was paid, my lord. This is on the record, my lord. Thereafter, my lord, so he misrepresented himself first as the owner of the excavator. Thereafter, he said that, my lord, all the excavators were in good condition, my lord. So agreement was made at this Silapathar. But this telephonically, my lord, this this informant telephonically called to Tagung Niri, who was at Dulmuk. His residence is Dulmuk, my lord. Thereafter, my lord, what the informant did is, my lord, there happened, my lord, he had some liability towards other locals of that Yangkyung area also. So there, my lord, these other people, they took the excavator. So it is on the record that was seized by the police later on, my lord. And later on, my lord, what the informant of the present case did is, my lord, he manufactured a document saying that Mr. Tugunguri, I am not the owner of the excavator. Rather, my mother is the owners of the excavator. An agreement were made at Dibrugarh. Thereafter, he lodged FIR there. And this is how he managed to get all the excavator, two of the excavator back, man. Then, my lord, I got the this Tugung Miri got the pre-arrest bail application, and the Honorable High Court, while giving the bail application, also has categorically said this is a matter of purely of civil dispute, my lord, because, my lord, there was out of contract that machineries were taken, my lord. Now, my lord, feeling aggrieved, that feeling cheated, my lord, the applicant in the item number 12, my lord, he lodged the FIR, my lord. Now, if I read the FIR contents at Annexure 128, my lord, now being a officer in charge, my lord, is not it my duty to register the case, my lord? It is my duty to register the case, my lord. And I registered this case as Duimuk Police Case number 15 of 2018, my lord. Then, my lord, the investigation officer, not me, my lord, not the bail application. The investigation officer, he went to Sejosa, my lord. So in Sejosa, one excavator had already been seized by the Sejosa police in connection with some other case. So the Duimuk, the investigation officer, who is N. Niri, my lord, he went there, he seized the excavator, he brought to Duimuk, my lord, and it is on the record, my lord, still the excavator is at Duimuk police station, my lord. This is on the record, my lord. Now, this after inquiry also, this has come to the surface, my lord. Now, this informant, my lord will see, the FIR even, my lord will see 3 pages. My lord will find kindly page number 14, my lord, Annexure 3. This FIR itself speaks about everything, my lord. All this story, now he has made page number 14, 1 4, my lord. 14, 1 4. Now, my lord, this is 3 pages. If my lord wants me, then I will go. Otherwise, my lord, the substance of the allegation is only that, my lord, that the applicant was the officer in charge, my lord, along with the Tugung Niri was the informant of the case, the victim, my lord, and other police officer. Now, the allegation, sweeping allegation made in the affair that they had entered into conspiracy. Thereafter, they had brought the excavator. This basis, my lord, now my lord will find and 182. Now, so far section 403, my lord, this is a bailable offense, my lord. 182 also bailable offense, my lord. 182 cannot be registered, but still, even if it is there, this is a bailable offense. Now, my lord, we will see only 406, my lord. Now, how 406 will be attracted by? If I take what this 406 says, my lord. My lord, 406 is basically punishment for criminal breach of trust, my lord. I'll just read the 406 section. Whoever being in any manner interested with property.
IPC.
My lord. 405 is the definition, my lord. 406 is the punishment, my lord. It's up to only 3 years, my lord. And this is also compoundable offense, my lord.
Criminal breach of trust.
Yes, my lord. This is only the section non-bailable, my lord, out of 3 sections. My lord, I'll just read the provision, my lord. Whoever being in any manner interested with dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any other person so to do, commits criminal breach of trust. My lord, what is the requirement, my lord, of this so far this particular section is concerned, my lord? First, my lord, the person has to be interested with some property. Second requirement is, my lord, there has to be dishonest misappropriation, my lord. Thereafter, my lord, that too, my lord, in violation of any direction of law on so and so, and any legal contract expressed so and so. Now, here is the question, my lord. It is on the record, my lord, from the preliminary inquiry made by the police, my lord. The property is still at Dumu police station. That excavator, which he is alleging, that was for which the conspiracy was hatched, my lord. So that is still there in the Dumu police station, number one, my lord. Now, my lord, now where is the question of, my lord, misappropriation? Now the officer in charge, my lord, he has not entered with any contract with him, my lord. And the property which was seized during the exercise of the, my lord, power, my lord, that too by the investigation officer, that not by me, my lord. I was only the officer in charge, my lord, at that point of time. And that property was brought there by the investigation officer, and that property is still there in the Dumu police station, where the question of, my lord, misappropriation comes here. Not at all, my lord. Now, basically, allegation what he is saying, now he is raising the issue that since that excavator had already been seized in connection with some Sejusa police case, so the investigation officer, without following the process of law, why that was seized, my lord? Then, my lord, how that can become a, my lord, criminal offense? If it is there at all, my lord.
This Sejusa, the FIR,
my lord,
is filed by whom?
That was filed by the present informant, saying, my lord, because that excavator was found working there under the jurisdiction of the Sejusa.
Okay.
So against unknown person. So that was seized by the police there, my lord. Thereafter, the Dumu police, my lord, when I lodged the applicant in the item number 12, when he lodged the FIR, then, my lord, went there and brought the materials here, my lord. It is still intact there, my lord. My lord, therefore, my lord, this is the section, my lord. So for 403-405, this is only the non-valuable section, my lord. Otherwise, other sections are also not abstracted, my lord. So, my lord, since there is no requirement of custody at all, my lord.
Lordship, may I make a humble submission in the matter?
So, my most probably, my lord knows the parameters of bail, my lord, and this is the offense below, my lord, 7 years also, my lord, and no need of custody interrogation here in this case, my lord.
Lordship may kindly allow me to bring.
There is no prima facie case at all.
Case has been registered.
My lord,
obviously. Has been registered, no?
My lord, registered, my lord, and I this 41A notice was issued to me, my lord.
Okay.
And my lord, after getting the protection from this honorable court, I appeared, my lord.
And you were arrested also. You were arrested and released on bail because of the interim orders.
Okay.
That much also has to be brought before the notice of the court.
Yes, we know about these things.
You know, but why are you suppressing the facts? If you know so, you should have brought it to the notice of the court.
Yes, Mr. Just wait, we'll hear you on appropriate, at appropriate time. Just wait.
So here is the, my lord, the parameter, the facts is like this, my lord, only. The allegation. So even if I take, my lord, entire statement there as in the FIR, as it is, my lord. Now question comes, what is the offense? Under which criminal section, my lord? Let's say, my lord, whatever written there is truth. Let them make which section will be applicable to me. My friend has to understand that parameters, my lord. That, my lord, I will after that, my lord, let him.
Yes, PP.
We have received the case diary.
And so far, the investigation part is concerned, my lord. Altogether, assistant prosecution witness has been examined under 161 of the CRPC. Altogether, 16 prosecution witnesses.
16.
16. 16 prosecution witnesses are examined under 161 of the CRPC. And accordingly, my lord, in the present case, my lord, there's a slight different story which has been narrated by the petitioner for the counsel for the petitioner, my lord. In this case, there are multiple FIRs, my lord. Initially, the present complainant has filed a FIR at Sijusa police station against some unknown person, which was registered as Sijusa PS case number 9 of 17. And during that investigation, my lord, the complainant's mother's excavator, which was used by one of the prime accused Tagung Niri, was seized by the Sijusa police station. That is one part. Now, second part is that the prime accused Tagung Niri, he files a FIR at Doimuk police station against the and without any court's order. Now, what they does is that they brings back that excavator to Doimuk police station, and instead of keeping that excavator in Doimuk police station, they have handed over that excavator to one of the prime accused, Tagung Niri. And since then, he has been using it. Now, stating that the submission which has been made, stating that the excavator is still at Doimuk police station, is a wrong submission to my understanding. Now, so far, my lord, the investigation part is concerned, my lord. With all fairness, I have submitted the status report, my lord. If my lord peruse it, the investigation part is over, and both the accused are complying with the orders of this honorable court, and they are appearing as and when being called by the investigating authority. There's a bit variation in the facts submitted by the counsel for the petitioner.
Investigation is completed.
Yes, my lord. In the verge of filing of charge sheet, my lord, except they are waiting for a final report of the Doimuk police station so that they can initiate a proceeding against the prime accused Tagung Niri for filing a false FIR. Only that part. Otherwise, investigation part is over.
My lord, my lord, page number 32 of our application. My learned friend has said, my lord, so far excavator, where is the excavator, my lord? I will read from the record of the, my lord, inquiry officer, the present case, page number 32. That will clear, I think, my lord.
Yes.
Learned PP has not, I think, gone through the record.
I've gone through.
Page number 32, my lord. Of page number, present case.
In fact, my lord, what they have done is that the IO and the concerned OC, they have brought back the excavator and they have replaced with one other excavator, man. And the main excavator which was in dispute has been handed over to the man accused Tagung Niri. That is the fact.
Page number 19, madam. My present application. Page number 19, madam. Para 5. During my inquiry, I have minutely checked the excavator which is now there at Doimuk police station. I could not find the serial number, so and so he is saying, madam. But excavator is there, madam. Now there is a investigation is going on whether there is that particular excavator or not. I think this is what exactly. But there is a excavator. This question of misappropriation is not there.
This is after the present FIR.
No, my lord. Before my lord registering this FIR, this inquiry was done. Pursuant to this inquiry has been treated as a FIR. Pursuant to this inquiry only, my lord, FIR was registered.
Okay.
And my lord will see, so far my Duimuk police station case, my lord, which was registered pursuant to my FIR, my lord, the final report was submitted, my lord. Then, my lord, now, my lord, I am agitating because, my lord will find here in that investigation, although there are sufficient materials, but wrongly final report has been filed, my lord, and we are raising that issue for further investigation. We have even filed one application under 156 before the learned Chief Judicial Magistrate, my lord. That is pending consideration for further investigation. Because why, my lord? My lord, I will just, my lord, kindly see once page number 19, my lord. The recommendation of the Magatago, the inquiry officer, para 6, my lord, page number 19. Duimuk police case number which was submitted into FIR may also be reopened as this case is related to the seizure of so-and-so. So there is a, my lord, recommendation by the inquiry officer also, my lord, that my case need to be reopened, my lord. Why, my lord? That pertains to the, my lord, this present excavator only, my lord. This is the subsequent development.
Anyway, if the investigation is completed, what?
Nothing is there, my lord.
Nothing is there.
Lordships, may I make a submission now?
On what basis I should hear you?
Sir,
For
I
what?
am the informant who has lodged this complaint.
Are you a party?
Yes, sir.
The bail application?
I am the informant who has lodged this complaint.
You may be the informant. You have put your FIR. It has been investigation. Is completed. What can we do?
Sir, the investigation is not yet complete. The excavator is not at all recovered.
It's not recovered. If
It's not recovered, sir, till now.
It's not question of recovery. If the learned PP submits that investigation is completed, then what can we do? There's nothing.
Sir, I just humbly pray that let the learned PP be asked to file an affidavit stating that excavator 676 has been recovered, along with the photograph of that particular portion of the excavator which says.
For what we have to hear you? On what basis? On what capacity? We know that you are an informant. You cannot be a party to the bail application. Are you a party?
Best of the knowledge of law is to with you, sir. I am not a person to make a comment on that. But in the interest of justice, if I am heard, the matter will be more crystal clear. And
you have filed an FIR. Investigation has been carried out, right?
Yeah, sir.
Whatever is there, it is not the police to punish or whatever.
But sir, if
see, on your filing an FIR, whatever you want, that will not be given to you.
That is true, sir.
The police has their own role to play.
Right.
After the investigation, whatever is there, they will submit before the court. The court will decide.
Sir,
now listen. At this stage, we are considering whether the bail can be granted or not. That's all. We are not here to decide today whether they are guilty or not.
That is true. That is true, sir.
So,
sir, in item number 12, the petitioner has attached a forged document which he had earlier attached in the Guwahati High Court bail application, which was found to be forged.
That will be decided before the appropriate forum. It's on a bail application. It's a bail jurisdiction only.
But sir, attaching a forged document amounts to contempt of court.
What?
Item number 12, the petitioner had attached a lease agreement which has already been charge sheeted to be forged.
Well,
in the next item, my lord,
we are very lenient, though you are not supposed to be heard. We are hearing you, right?
Right.
We'll take it up. Yes.
Yes, my lord. But this is the case, my lord.
Hmm.
Considering the facts, allegation may be there. Now the question is, my lord, since so far that excavator is concerned, my lord, that is the from the record inquiry report itself saying that that is there in the police station. Now the question, my lord, this other only the section we have to say 306, this 305, criminal breach of trust, which I have read, my lord, that doesn't attract at all, my lord. That misappropriation of property is not there at all.
405.
405.
Hmm.
Other sections are not applicable, those are bare level. So here is the case, my lord. Custodial interrogation is this is the case not required. I think even the police has not asked for, my lord, custodial interrogation.
Yes, Mr.
Lordship.
Yes.
May I?
Yes.
Lordship, the case has been presented in bits and parts to suit their own purpose. May I be allowed to present the entire case before you?
No, because on what capacity we should hear you?
On the last occasion, I had sought the leave of the court to file an affidavit in opposition to protest the petition. But since the petition's copy was served very late by my advocate to me, I was unable to file. So I waive off my rights to file an affidavit and I come here protesting. That's it.
One more issue, my lord.
Yes, what is the procedure if the informant or the victim wish to?
No, they do
wish
have
to be
a
heard.
they do have a participatory right, but so far the provision of 301 of CRPC is concerned, man. They can only assist the PP. They
Yes.
cannot make a independent submission.
And here,
Lordship, any submission will be made in the interest of justice, not to pacify
My
any
lord,
particular
one
public
more
prosecutor or
difficulty.
any
No,
counsel.
let us do one
My lord,
thing.
one more difficulty.
If since he is insisting, let him. You implicate him in a party.
My lord, here is one issue. His locus itself in question. Why, my lord?
That's it.
Here is the victim. He is not the victim. His mother. Now,
See, as per the provisions of the law, you have a right to participate in the proceeding in the
Yes.
bail jurisdiction,
Yes, sir.
but only to the extent of assisting the PP, right?
Right, sir.
So, since you are vehemently try to place your case, which this court has, I mean, cannot hear you, it's law is not permission. It's law is not. It's not permissible. So we'll list this matter on other. I mean, on next date. I mean, some other day. You assist the PP whatever you want to make your submission, right?
Highly honored, sir. I will do that. And in the next item,
And I think we're conscious. We cannot deny the litigants or the lawyers to appear through BC, but the practical difficulty has to be seen.
yes,
It has to be understood also.
it's,
Therefore, if you want to assist, I think better you come physical here and assist the PP,
yes,
because it's a law only permits you to assist the PP. While sitting there, where are you from? Where are
I'm
you?
from
I mean,
Calcutta, sir.
Ghaziabad. So
Kolkata, sir.
even the court is finding it difficult to hear you through BC, but we cannot deny.
Right.
Therefore, if you really want to assist, as per the law, you have the right of assistance to the PP only. So you come and whatever you want to do, you assist him. We'll give you another chance. We cannot hear you like this.
Okay, sir, we will do it properly.
It's not all the case, it's a bail jurisdiction.
Right, sir.
Otherwise, this is listed for hearing. I find it prima facie after hearing and after perusal of the case diary, there's no requirement of custodial interrogation. You may have you may have case on a different thing, and it's basically, I mean, whatever they have completed the investigation, whatever is there. Anyway, we will fix some other day. You retain the CD,
my lord.
In both the matters, Lordship.
In fact, you may, of course, you have investigation is completed.
Completed, my lord.
Then no status is required.
Not required.
Can you produce any status?
If any, I'll just try to.
If any, huh?
Yes, my lord.
Let us do it like this, because tomorrow Mr. Agarwal may say, I have not been heard properly. Hearing has to be effective. But I make it clear that you will not hear you. You have the right to participate in the proceedings by assisting the PP.
Sure, sir.
Right? All right.
Yes, sir, we will do that.
You cannot argue independently.
Right, sir. We
It's
will
a bail
assess the PP.
it's a bail jurisdiction.
Right.
Because why not in these proceedings, we are not deciding whether the accused is guilty or not. That is the matter of the trial. And in the present case, the investigation has already been completed. That we cannot change it, right? Anyway, heard Mr. Arson learned counsel for the petitioner, and also heard Mr. Jambe.
Yes, sir.
Learned PP for the state. Practically, the learned counsel for the applicant and practically the hearing of the bail applications is completed. Just however, on the insistence of the informant who appears through BC, the matter is adjourned for another 15 days so as to enable the informant, Mr.
Manish Agarwal, sir.
Manish Agarwal, to assist the learned public prosecutor in terms of the provisions of the law. Mr. List this matter after 15 days.
Right.
15 days.
Thanks.
Obliged.
Thank you.
Why making it clear, Mr. Agarwal?
Yes, sir.
You cannot be heard independently. You cannot make it whatever you want to assist, whatever you want to say. You have a right to only assist the PP, right?
Yes, sir. We will do it. Thank you, sir.
Interim order passed earlier shall continue.
Next item also similar order.
Same order.
11 and 12. Biblio.
Otherwise, unnecessarily, we could have adjourned it. Where was so much?
नहीं हुआ ना ऑर्डर, हम नहीं चिल्लाता तो जज दे देता ऑर्डर, हम कर दिया ऑफ कर।
These are the nuisances of BC and all, but we're bound. There is a binding direction. We cannot refuse.
Yes.
But it's very difficult.
Yes.
If we cannot effectively hear them and take up the matter, what's the use of having all this? It's become unnecessary a nuisance. Yes,
My lord, in this case, LCR is not yet called.
why LCR is required?
Because my lord, this is application under 115 of CPC.
Huh? LCR is required.
Yes, my lord.
Who wants to file the affidavit? Who appears for?
I am for
You
respondent.
want to file any objection?
No, man.
Okay. Heard, Mr.
Dalbong, man. Dalbong. Dalbong.
For petitioner.
Yes, my lord.
Learned counsel for the petitioner. A. Dalbong.
Yes, man.
For, and Mr. Orin.
Yes, ma'am.
O. Modi. Learned counsel for the respondent. It is stated by the learned counsel for the parties that trial court records would be required. Mr. Accordingly, call for the trial court record. Yes, sir.
Your Lordship, the
Who appears for 1 and 2? PP. What is this? What is this?
Your Lordship, I'm extremely sorry, Your Lord. The brief is not with me. It is actually endorsed to my learned sister El Hage. And the brief is not with me now.
Where she is now?
She is not present today, Your Lordship.
Okay. Let's some other day. When? What is to be done today? Do we need to file any affidavit?
Your Lordship, it's
Office note says affidavit not yet filed. By respondent number 1 and 2. Who are 1 and 2?
one will be state only most of the time, especially simply that.
Why, what is the matter? Sir, tell
it
us.
is the
No, one is Mr. Tamar Jerang.
Okay, a private respondent.
Notice completed. Service completed.
For orders, Your Lordship.
Notice. Service completed. Mr.
health department.
For learned counsel for the petitioner and Mr. Both will be taken up together.
Yes.
That's a common order, huh? Mr. T at the learned edition PP is present on behalf of learned edition PP, MS El Hage.
Yes, Your Lordship.
Non-APS for respondent number 2. List for admission hearing after 3 weeks.
Oblige, Your Lordship, deeply obliged.
Well, in this case, I am representing all the respondent.
Okay.
I may be allowed some more time to file my affidavit.
Affidavit.
Yes, madam.
Affidavit is required.
Yes, madam.
Yes, madam.
Heard Mr. A.
Dalbong, man.
A. Dalbong, learned counsel for the petitioner. Mr. O. Modi, learned counsel for the learned counsel appear on behalf of all the respondents. Press for it is granted 3 weeks time to file. Objection, if any.
Okay.
No objection, list after 3 weeks. Yes.
Your Lordship, on last occasion, CD was called for, and we have received the case diary.
Yes.
And it's an original one, Your Lordship. So perhaps today the petitioner side is absent. They're challenging on the merit.
On
Regarding,
merit.
yes, Your Lordship, an FIR on registered under 498A and 323.
498A.
Yes, Your Lordship.
Okay. 498 is applicable. None appears for the petitioner on call. Mr. The learned additional PP submits that he has received the
Case diary.
case diary in original. Send back, we'll send
Yes,
it back.
we'll send it back.
Mr.
Keep eyeing for respondent number 2.
We find for respondent number 2. Mr. Since the learned counsel, the petitioner is not represented, the case diary be sent back. Next after 4 weeks.
Deeply obliged.
Yes.
My lord, service report is awaiting.
Okay. Await service report. Mr. Odugong, and counsel for the petitioner is present. This after 4 weeks.
But there is interim order, my lord.
Interim order first, shall continue. Yes. What is this?
For SK raised.
Ah?
Some adjournment is sought. The service is complete.
Mr. SK DK Devi. DK learned concept of the petitioner is present. None appears for the respondent. List after 4 weeks for admission hearing.
Obliged.
Yes.
The service report in respect of respondent number 2 is awaited. Your lordship, step was taken on 12th March 24. I may be allowed to take first step upon respondent.
The learned counsel for the petitioner is permitted to take fresh steps for service of notice upon respondent number 2 within 2 days. Mr. Theatre learned additional PP is present. List after 4 weeks. You take the steps within 2 days, letter will be listed after 4 weeks, right?
Obliged. Your Honor, there is an interim that may be
Interim
continued.
order first, shall continue.
Deeply obliged.
Your Honor, leading counsel is appearing session court.
Okay.
So the matter may be kindly pass over to last.
Don't make such a submission. We'll adjourn that matter, definitely, but don't say that when you're making a submission before the High Court, don't say that is appearing in the sessions court. Right?
Or
don't repeat that. On the prayer of learned counsel for the petition, what is to be done? Yes, PP, item 22.
Again, your lordship, again, this matter was endorsed to El Hages. He is not present today.
On the joint prayer of learned counsel for the parties, list this matter after 4 weeks.
4 weeks.
Okay.
4.
Interim is there.
I don't know, my lord.
There's no interim, right? Just after 4 weeks.
All right.
Deeply obliged.
Yes, my lord. Step has been taken.
Yes. So,
My lord, we wanted an interim prayer on this also. There was an interim prayer also.
Huh?
We wanted an interim prayer also, you know.
What interim prayer?
That the criminal proceeding may be stayed.
We'll wait for some time. Yes. What is this?
My lord,
They want interim prayer. Who is investigation? Stay the investigation.
no,
no,
my
no,
lord, the charge sheet, my lord.
The
My-
criminal proceeding, your honor. My lord. The criminal proceeding.
My lord, in my humble opinion, my lord, it's a premature application, my lord. my lord, the charge sheet was filed, my lord.
Hmm.
Investigation, then a charge sheet was filed. Now it seems, my lord, on the first date of the appearance, my lord, in the charge sheet, there was a prosecution sanction.
Hmm.
And it seems that that prosecution sanction was wrongly issued. Because the present petitioner, he is an IFS officer. And the prosecution sanction was supposed to be taken from the central government, but it was issued by the state government. So the cognizance was taken by the learned trial court and process was issued. And they file an IA for the charge of the petition. Then they have informed the court that the prosecution sanction which was issued is a wrong prosecution sanction. And since the prosecution sanction is wrong, no cognizance can be taken. And when even the cognizance cannot be taken, the question of discharging does not arise, my lord.
Yes. You'll have to wait for some time.
My lord, I'll just give you citation also.
No. What is this citation?
No, my lord, I'll just explain. My lord, they have taken cognizance on this. This is my annexure number 8.
Cognizance has been taken.
Yes, cognizance has been taken.
Yes, my lord.
There is an annexure number. There is an additional affidavit. This is on 26/7/2023.
Page 4, my lord. What does it say, my lord?
There is an additional affidavit.
The case is taken up today for the first time. That is what I have submitted, my lord. It was taken, the cognizance was taken on the wrong notion, my lord, thinking that there was a prosecution sanction. However, when they filed the application, it was seen that this prosecution sanction which was issued was wrongly issued by the, it was issued not from the competent authority. But cognizance was taken on the notion that it was a proper prosecution sanction. Now, when they themselves apprised the court that it is this prosecution sanction was not issued from the competent court, then how can cognizance can be taken, my lord?
Therefore, the cognizance, taking of cognizance, whatever may be, is no cognizance.
My lord.
Knowledge.
Knowledge.
Therefore, this criminal proceeding may be stayed.
So
No,
until
in this
unless
case, you cannot just stay there. We'll see on next day.
Page number 174. Third page. It this will be para 3 in para 21. If para 3, it will be in 31. It is well stated that any case instituted without a proper sanction must fail because this being a manifest difficulty in the prosecution. The entire proceeding are rendered.
Where it is?
It is in para 3.
A perusal of the resolution.
Yes, Your Honor. On the 23 para 3, the 23rd sentence. 23rd sentence. It is well settled that any case instituted without a proper sanction must fail because this being a manifestly difficulty in the prosecution, the entire proceeding are rendered void ab initio.
I'm not getting it.
This is
Line
23. 1. Three 24.
It is well settled.
Yes, it's well settled that any case instituted without a proper sanction
Must fail
So-
because this being a manifest difficulty.
My lord, the case here is that the petitioner is an IFS 2016 Akmut Kedar. Although he is a central government employee, the sanction has been granted from the state government.
What is the status now?
It speaks for production of proper sanction.
Sanction.
We are awaiting the proper sanction, ma'am.
For production of proper sanction. But already this cognizance is taken already.
Now, law demands, my lord, until unless there is a proper sanction, my lord, cognizance cannot be taken, my lord. That is true, my lord. But in this instant case, my lord, cognizance was taken on a notion that that prosecution which are issued is a true
It was
prosecution
earlier
sanction.
fixed for consideration of charges. Then we had filed a discharge application to discharge due to the improper addition. Sanction. So without discharging the session court has passed an order that the IA may be stayed till proper sanction is accorded. That is in para, but that is in my annexation number 6 of my petition. They are also admitting it that this is not a proper sanction, but they have taken cognizance. So without having any this, they have taken.
Where is that order taking cognizance?
That is in my additional affidavit, page number 4.
Page number 4 of the IA, my lord. Oh, so additional affidavit, my lord. Page number 4. Additional affidavit, my lord. I think my lord is perusing the main petition, my lord. The IA, my lord.
Where is the IA?
No, there's no there was an additional affidavit.
Yeah, additional affidavit.
Yes, sir. Additional affidavit.
Main petition.
This order 15.3.
No, it's 26/7/23.
देखो तो उसको लाओ ना.
What is the allegation?
Allegation is under 120B and 7 of PCA. So allegation is for demanding bribe.
My lord, this present applicant, the petitioner, he was working as a DFO at Manadua, and he was caught red-handed taking bribe from the RFO was caught red-handed while taking bribe from the contractors. And during the course of investigation, it was informed that he was the one who instructed the RFO to take that bribe.
Now, section 19 of the PCA says
When is the next date fixed? When is the next date fixed?
next date is fixed for 30 October for production of proper sanction. Last time it was on 7 May, this 7 May. And next date is for 30 October for production of, since it's a
30th October.
30 October, 30.
30.
Yes.
Who is respondent number 2?
Respondent number 2 is a private complainant.
Then we have a time, we'll consider your interim prayer on next date, right?
Next date.
We have a time. No prejudicial post. All right. Because
but
Edicard is yet to be received back.
Yes,
We'll mention that your interim prayer shall be considered on the next day. All right.
Otherwise, also
because if it is fixed on 30th of October, or Mr.
Empertin,
and consent for the petition. Also, and then Also heard Mr. Opa the learned special PP. For SIC
Vigilance, my lord.
SIC within bracket, BIG, bracket close. Office note dated 08/05/2024 reflects that service reflects that the service of notice upon respondent number 2 is still awaited. Is still awaited. Is awaited, not is still, is awaited. This matter after 4 weeks. On the next day, the prayer for interim shall be considered. Then a prayer for interim shall be considered on the next date. All right. You take it back. This, there is no additional affidavit.
May your lordship.
Yes.
Lordship, this is an application for quashing of an FIR, your lordship.
Yes.
Giving rise to usually PS case number 48 of 21. Under section 417, 420. Read with section 138 of Negotiable Instrument Act. Your lordship, as per the last order, letter status report was supposed to be produced by quickly.
Lordship, this matter may pass over for the time being, your lordship. It's been looked after by learned brother T. Jita, your lordship.
This is the last case, I think.
The second last case, your lordship.
Huh? It's the last case.
Okay.
Lordship, he
So
was
what
here
are
this
they
morning.
in that case?
In
Next
that
week.
regard, your lordship.
Next week.
Yes, next week, your lordship. Can it be on?
Heard Mr. Enanju, learned counsel for the petitioner. Mr. In view of the absence of Mr. Jitado, learned additional PP. Come on, list this matter after a week.
Lordship, I'm trying to fix it. Can it be on 16th of this month? 16th.
16. There was a direction?
Yes, your lordship. Yes, there's a direction as per the order dated 26.
You are for a quashing of the FIR?
Yes, your lordship. Because the matter is purely a dispute, civil dispute, your lordship.
Including 138?
138, your lordship.
138 to...
Under 138, the FIR cannot be registered. No doubt, your lordship.
Respondent number 1 has, without any jurisdiction, he has
Wrongly registered under 138, your lordship.
The learned additional PP shall produce the status, updated status report as directed by this court. That is 26/09/2026. Interim order pass, earlier shall continue. Next para, huh?
Deeply obliged.
16.
Lordship, I forgot to mention there was an interim in item number 15 and 16.
15, 16?
Yes. Problems.